The law is complex, but it doesn't have to be a mystery. We are talking legal literacy, not advice. So don't worry, you're not getting an invoice. I'm Simon Jenga, and welcome to Simon Said. Today we are asking the question, what is a PPPR Act application? So, if you already know what that term means, you are going to be deep or at the beginning of a journey through a court process. But let's start with our building blocks to make sure we're all on the same page. So, what is the PPPR Act? This is the Protection of Personal and Property Rights Act 1988. There is a number of things that this act is designed to govern, but what we're going to focus on today is the nature of applications for the court to appoint someone to manage someone's property or to make decisions for their personal welfare. So those are the two things that we're specifically looking at in terms of the Act today. So what is a PPPR Act application? This is an application through the courts to appoint someone into one of three roles primarily. The first is property manager. The second is property administrator or administrator of property. And the third is welfare guardian. As you can tell, the first two are linked. A property manager is empowered with the most amount of power that the court is going to give to an individual managing someone else's property. Effectively, they step into the person's shoes and they manage all of their property affairs on their behalf. There is no limit on what the value of the person's assets could be for a property manager to act. Now that can be contrasted with an administrator of property or a property administrator, where there is a specific restriction on the amount of assets someone can have for a property administrator to be appointed. You might be saying, why is that relevant, Simon? Well, the two main differences between a property manager on the one hand and an administrator of property on the other is that a property manager is required to report to the court annually with a summary of assets, what has been spent, so that the court can keep a record of what it is that you're doing to make sure that you are discharging your duties as property manager. It's effectively a check and balance to make sure that the court appointed person is actually doing what they should be doing in accordance with the directions of the court and the PPPR Act. In the schedule to the Act, there is a schedule which outlines all of the powers that the property manager may be able to exercise on behalf of the subject person. Now, when the court does an order appointing the person as property manager or administrator of property, it will outline exactly what provisions in that schedule apply and therefore what powers the property manager or property administrator actually has in respect of managing the affairs of the subject person. Now, if we compare that property manager duties to the court on an ongoing annual basis, that can be contrasted with the administrator for property, where they are not required to file annual statements of position for the subject person. And that's on the basis that there's not a significant amount of assets. It seems unnecessary to put that administrative burden on the property administrator, and therefore they're not required to do annual check-ins. Effectively, when you are applying to the court, you're either going to be looking for an appointment as a property manager or as an administrator of property, not both. Whereas it's likely that one of those applications will be paired with an application as welfare guardian. Now, this is where someone is appointed to take care of the personal affairs of the subject person. Decisions at the hospital, decisions about care, decisions at the end, all critical decisions that need to be made, and therefore it's a separate application, and it could be a separate person. One person appointed to manage the finances of the person and another person appointed to manage their personal care. At the end of the day, the duties between those two people are to consult with each other and to work collaboratively for the benefit of the subject person. Or it could be the same person acting with two hats effectively. Now that brings us to the difference between appointments under a PPPR Act application and enduring powers of attorney. Enduring powers of attorney being designed that they are signed by the subject person, which we'd normally call the donor in that context. So they're signed by the donor, appointing specific people to look after property and to look after personal care, as opposed to these court applications where it's the court that is actually determining, ultimately, who is going to be appointed. Granted, that's on the basis of who makes the application. You've got to be in it to win it. So if someone loses capacity and there needs to be an appointment by the court is going to be limited to those people that are putting up their hands as applicants to appoint, or alternatively, if there's no satisfactory applicant, then the court will be looking to public trust entities, such as public trust or perpetual guardian. So the difference between having enduring powers of attorney and needing to go down the court process is, you guessed it, signing enduring powers of attorney. If you don't have them, then you have to go down a court process, and there's no other alternative once you have lost capacity. And remember, there's a number of ways that you can lose capacity. It's not just progressing in years and developing a degenerative disease, Alzheimer's, dementia, Parkinson's. Those are all possibilities, and unfortunately I still do have clients that haven't signed enduring powers of attorney into their later years. Oh, I'll do it next year. Oh, I'll be able to do it at some point. I'm not quite sure who I want to appoint. I'll leave it till next year. And then suddenly a loss of capacity occurs. They're no longer able to sign documents themselves and are forced by the family, or rather through the family, down a court process. So that is the big way that people lose capacity on an everyday basis. But there's also a number of other ways. There could be an accident, which is sudden. Often, not often, you can't control whether it happens when you're young or old. You could be 30 and have an accident. You could be 70 and have an accident, and decisions need to be made about you. So it's not necessarily as likely at 30 that you're going to need enduring powers of attorney. But if you don't have them, and you lose capacity, we're going to be going to the court. Another way that you might lose capacity is through a stroke or a sudden event that is higher risk as you progress in years. Again, your risk profile is just going to increase and increase and increase over time. So if you are in your 50s, my recommendation is to give serious consideration to putting in place enduring powers of attorney to make sure that we don't end up with a court application being necessary. The last main way for people from a health perspective coming into needing to do an application through the court is when you are entering a rest home. So perhaps you haven't signed enduring powers of attorney, or someone you know hasn't. Perhaps it hasn't been an issue up to this point because you've been able to manage the hospital and manage having them at home. Anyone that you've engaged with really hasn't asked too many questions. You've been able to effectively have quasi-authority over that person, or they've had sufficient capacity to be able to manage and navigate those situations. As soon as that subject person is needing to go into a rest home environment, the rest home will not accept them without enduring powers of attorney or court orders for property manager and welfare guardian. Now, the reason for that is very simple. The villages, or rather the rest home care hospitals, they don't want situations where there is no one legally entitled to make decisions for one of their patients. Practically, it makes life difficult for them, and it also becomes a nightmare legally with the family and the rest home facility arguing over who is making the decisions about that person. So if someone is approaching needing to go into rest home care, then if you have been, let's say, fudging it to that point, there is going to be a hard line coming where court application will be necessary. The last category of the majority of cases that I see is where someone has an intellectual disability. Now, when someone has an intellectual disability and they are a child, an infant, being someone who is from 0 to 18, the parent or guardian continues to make legal decisions for that child. And right up until 18, the parent is authorised as their legal guardian to make decisions for them. As soon as they turn 18, there's a presumption at law. And when I say at law, I mean a presumption in the law. The presumption under the laws of New Zealand is that that child gains capacity to make their own decisions. The parent loses capacity as their guardian to make decisions now that the child has clocked out. And therefore, if there is a persisting intellectual disability, that means that the child is unable to make decisions for their own care or their property, then an application under the PPPR Act is required in order to sustain authority to make decisions for that child. It seems counterintuitive. It seems that as their parent in the medical system, that the child is known to the doctors, it's known to the hospitals, it's known to their care facilities, it's known to their lenders or their funders, whether it's state or private. It seems odd that you then at this arbitrary date need to make an application to retain authority. As I say, it's on the basis of this presumption that at 18, a minor gains capacity and the parent loses the right to make decisions for them. So that's a critical time where if you know someone or you have a child that has got an intellectual disability and is not going to gain capacity as an adult, then being prepared for that birthday so that you know this application is coming, you can prepare it ahead of time. We can't file it until the child actually reaches 18, so there's nothing we can do in terms of doing it in preparation or in anticipation of turning 18, but we can be ready so that once they're 18, the application is submitted and the process is started. So that is the last category which can catch people out and cause anxious times, both with the medical industry and with how the child's life is being funded through state support. So today, Simon says, if you know someone that lacks capacity, is heading towards lacking capacity, or may never gain capacity, then now is the time to have an honest conversation with them or their loved ones about whether enduring powers of attorney are required or whether it's already progressed to needing to get the court involved. And remember, at LOA Law, we are good lawyers for good people.